Good morning, Mr. Chief Justice.
Did you say good morning?
Good afternoon.
Oh,
Sorry.
okay.
Good afternoon, Mr. Chief Justice. May it please the court. My name is Alicia Torres, and along with my co-counsel, we represent the defendant, Mr. Guerrero. At this time, the appellant requests 1 minute for rebuttal.
How many?
1 minute.
1 minute, okay.
Thank you.
So you represent the appellant, Mr.
Yeah.
Pujols?
Yeah, Mr. Pujols, yes.
Okay.
I will be discussing the standing issue and the locally inapplicable issue, and my co-counsel will be discussing the substantive due process issue. An individual has standing under the International Covenant on Civil and Political Rights when Congress enacts a separate legislation that is reflective of the ICCPR. Here, the federal death penalty is related back to the ICCPR. Under Article 6 of the ICCPR, there's express prohibition on capital punishment for anything other than a heinous crime. And here, the federal death penalty prescribes capital punishment for various crimes. However, a defendant still has to prove that he has standing under the Federal Death Penalty Act. For us, he has imminent harm caused by the respondent in this case, and only a favorable redress by this court will solve that. He is facing the death penalty. He has been harmed in that way. He feels the imminent harm. So we feel that under the Federal Death Penalty Act, he does have standing, and therefore he can bring his claim under the International Covenant of Civil and Political Rights. However, if the courts do not feel that our client has standing under the ICCPR, we still find that the Federal Death Penalty Act is locally inapplicable to Puerto Rico.
That's what you think?
Yes.
You said you find it.
Yes. If understanding if he doesn't have it under the ICCPR, we still feel like it's locally inapplicable under the Federal Relations Act because the Puerto Rican Constitution expressly prohibits. In order for federal legislation to be locally inapplicable, it must be irreconcilable with the Puerto Rican Constitution. It must conflict in some way. Here, Article 2, Section 7 of the Puerto Rican Constitution expressly prohibits capital punishment. Notwithstanding Congress's failure to actually expressly include Puerto Rico in the death penalty, there's no congressional intent that shows that they intended to have the breadth of the federal death penalty over the island either. Congress ratified the Puerto Rican Constitution after several amendments. At least 3 times they saw the Puerto Rican Constitution, and not once did they strike the prohibition.
Now, didn't Congress say it's okay internally for Puerto Rico not to establish a death penalty?
Yes, Your Honor, they did allow
But did that inclusion preclude the federal system from having a death sentence for all citizens?
Only in the sense of Puerto Rico, and I think here it's that Congress did not they intended for this federal death penalty to not be applied to Puerto Rico because they didn't include it in the federal death penalty.
Did they exclude it?
They didn't expressly exclude it, but
did they exclude anyone?
They excluded the Native American tribes.
Okay, so they excluded the Native American tribes, but they forgot to exclude Puerto Rico.
Well, I think that the Native American tribes are a fundamentally different dual sovereignty under.
And Puerto Rico is not sovereign.
It is sovereign, but it's a different relationship between the Native American tribes and Puerto Rico with the compact.
But isn't exclusion?
I'm sorry?
Isn't exclusion?
Well, you would also have to still look at the actual congressional intent. So even though they didn't expressly exclude them from the act, I still believe that they...
Well, what about the default clause? Does that include it because they weren't excluded?
I'm sorry, can you do that? So it should have
The intent was not to exclude Puerto Rico, wasn't it?
Well, if you look at the legislative history, it would appear that that's not it. It would have... the legislative history would have excluded it because nothing states within it that they wanted to include the breadth of the Federal Death Penalty Act.
So is anything in the legislative history that said Puerto Rico is excluded?
I'm sorry?
Is there anything in the legislative history that indicates that Puerto Rico is excluded from the Federal Death Penalty Act?
No, Your Honor, but there's nothing that expressly in the history.
What history should we look at then?
Well, I think you have to look at the relationship between the Puerto Rican Constitution and the Federal Death Penalty Act and the...
Well, what about Michigan's Constitution? Should we look at that?
Well, I think that there's a difference between the relationship between the states and the Commonwealth of Puerto Rico. They have a compact. They've enacted their separate constitution. They've the Congress has ratified Puerto Rico's Constitution without striking the death penalty.
In Puerto Rico for Puerto Rico's government.
Correct.
But not for the federal government.
Well, I believe that if they would have wanted to include Puerto Rico, they would have done so, since they're aware of their moral repugnance of Puerto Rico. They're aware of the moral repugnancy to the death penalty that the islanders feel.
Of course, the counter argument to that is that in excluding the Native Americans and not also mentioning Puerto Rico, there is an extremely strong inference that can be drawn that the intent was not to exclude Puerto Rico, because it would have been so easy to what they said with respect to the Native Americans. It could have been said about the Puerto Ricans too. The failure to do so, again, I submit, paves the way for a very strong inference that the intent was not to exclude Puerto Rico.
And we do.
But that's a good argument, though.
Well, we do understand that, and I just want to bring your attention to Colon v. Conti Perez, where they expressly included the District of Columbia for the Voters Protection Act, and they didn't include Puerto Rico, which again they could have if they felt that it went to them, but the Supreme Court felt that because there was no congressional intent there and they didn't expressly include them, that act also did not go to the Puerto Ricans. So I think it could be argued the same way. Thank you.
I think your time's up.
Very well.
Very good. Thank you. You may proceed.
Good afternoon, Mr. Chief Justice. May it please the Board. My name is John Peña, and I represent the United States of America. As a respondent, I think that it is important to do a historical page 680, when the Congress, including Luis Muñoz Marin, the governor and commissioner resident in Fernando Cicerne, but they have cleared that the plenary powers of the Congress will be and can be applied in Puerto Rico. One of the arguments of the petitioner is also that under the Article 2, Section 7 of the Puerto Rico Constitution, the death penalty, the federal death penalty, cannot be applied to the U.S. citizens residents in Puerto Rico. But it's a question that the petitioner didn't answer. Would be the Article 2, Section 7 of the Puerto Rico Constitution be preempted by the Federal Death Penalty Act? I will answer you. The intention by the interpretation of the U.S. Supreme Court when they established what is the interpretation of the Congress is clearly the national security of our citizens. It's clearly when I, as a U.S. citizen resident in Puerto Rico, the criminality, the insecurity in our island, and this is a kind of provision. This is a kind of law.
Counselor, but no one is arguing with you the other way. No one is arguing that the federal government apparently does have, Congress has the power to enact laws that apply to Puerto Rico. I think everyone agrees with that. I think the issue here is whether this particular law is one because of Section 9 of the PRFRA, whether Section 9 really contemplated this type of law being applicable to Puerto Rico. That's really the question. You know, the security of Puerto Rico is bad, and as citizens we should not fight the attempts by Congress to fight that criminality in Puerto Rico. Question is, are they doing it the proper way? Are they doing it in a legal way that does not violate Section 9 of the Compact? That's really the issue.
Thank you for your question, Justice. We cannot forbid what is our constitutional framework. The Congress, under also the Treaty of Paris in 1998, clearly in the last paragraph of the Article 9 of this treaty, Spain said, and I quote, that all the inhabitants, they cede the territories to the United States under the plenary power of the Congress. And the Congress today and tomorrow will be and have the power to extend and apply all the laws that they intend, that they think that are important.
But wasn't that affected by the Compact?
It's affected under the Compact because
I'm sorry, prior to the Compact, I think no one would argue against that. But then once the compact comes into existence, it changed somewhat the relationship between Puerto Rico and the United States.
Under United States against versus Quiñones, Justice, the First District Court established that when the Congress are agree and approve the Puerto Rico Constitution after the 82 Congress, they don't have the intention to change the relations and the power of the Congress. They just provide the power to the local government and to Puerto Rico to ordain and organize a local government. But it is not the same thing to say that then that the U.S. Congress cede his powers to the territory, because the Article 4, Section 3, Clause 2 clearly established that all the territories and property are belong the plenary powers of Congress, and Puerto Rico is a territory and is under the plenary powers before and after the 1952 Constitution approval.
You would not hear any disagreement from me on that point. But the thing is, and I throw it to you, under the territorial clause, Puerto Rico had and prior to the compact, Puerto Rico had a particular relationship. But once the compact comes into being, the territorial clause is not as
was to cede a Puerto Rican local government, cede powers to organize the local government, but because how I said before, one Congress cannot force another Congress to approve a law, and the 82 Congress intention, when we see the hearings in the pages 456 and so the Congress has the power and also amend the Puerto Rico Constitution, because they know that they have the power to do it.
Well,
After
isn't it really that Puerto Rico has the right to establish the penalties under Puerto Rico's law?
Yes.
But they don't have the ability to impose penalties or lack of thereof on the federal law, because they are different. They're on different tracks. Federal law is on this track, Puerto Rico law is on this track. Puerto Rico cannot dictate the penalties under,
yes,
but it can dictate, and that's the autonomy that Congress gave Puerto Rico.
But this is not the first.
That was a friendly question.
Thank you. This is not the first time that the Congress approved a law with a representation, with the participation of Puerto Rico. We can see it in Davila versus Lockheed Martin, when the Congress directly and with a representation of Puerto Ricans approved the Defense Base Act. After that, in United States versus Suarez, the Congress approved the Clean Water Act. And before that, when we see Moreno versus Rios, the Congress and the Supreme Court opinion clearly says that Puerto Rico has a different has a relation with the United States and has a local government establishing powers, but they never cede. The Congress never cede their powers to the territories or to other. Or their plenary powers over the Constitution. But the U.S. Supreme Court also, in Down versus Vigo and Barzal versus people of Puerto Rico, sustained that Puerto Rico is under the territorial clause.
So you're arguing then that it appears as though Congress has the unfettered, unlimited power to pass laws over Puerto Rico?
Yes, this is my opinion.
Does Puerto Rico, do they pay federal taxes?
Well, we pay it when we are paying the Social Security and other laws. And the Puerto Ricans that reside in the United States also pay that.
Let me ask you this question.
That's the federal government.
Yes.
Workers of the federal government.
But we in Puerto Rico, we can pay the Social Security, and it's a kind of taxation.
Let me ask you, was making the colonies and the colonists pay taxes. That brought up, I don't know if you guys may be too young to remember when it happened, but there was a Boston Tea Party
Yes.
in Massachusetts.
Were you there?
I was there. I was very young at that time, though. And what happened was, it was revolt against taxation without representation. Now let me finish. If we allow now, I'll finish this sentence quick. If we allow now for FDPA to come, then cannot the argument be made that this is matation without representation?
I can answer the question.
You bet.
Killing Maltation is my Puerto
Yeah.
Rican word. Maltation without representation. Just like it was taxation without representation. Isn't that the case here?
No, this is not the same. This is not the same thing, Justice, because the historic comparison between Puerto Rico and Canada is different, because the kind of Commonwealth that the United Kingdom approves in Canada was very, very different than the Commonwealth that the Congress approved in Puerto Rico. And the taxation without representation was an argument that when the public law, during the Public Law 600 operation, the governor, Luis Muñoz Marin and Antonio Fernández Isern, they are agreed that they have a common word to attend the local government matters, but they have a representation with a vote, and the people of Puerto Rico ratified this agree when his vote during the voting process of the Public Law 600. This is my argument. Thank you.
Thank you.
Very good. You may proceed.
Good afternoon, Mr. Chief Justice, and may it please the court. My name is Ashley Aguiar, and I too represent Mr. Pujols in this matter. I will be discussing whether sentencing Mr. Pujols to the death penalty violates the substantive due process. Now here, Your Honors, when we look to determine what violates substantive due process, we have to determine whether federal action shocks the conscience. And here, sentencing Mr. Pujols to the federal death penalty while denying him the right to vote in Congress shocks the conscience. Now, the standard for shocking the conscience is egregiousness. Now, courts must look on a case-by-case basis when we want to determine what is egregious. Here, because Mr. Pujols does not have the right to vote in Congress, sentencing him to death under that Congress shocks the conscience and is egregious. For example, in Rivera versus Puerto Rico, the District Court of Puerto Rico held...
What constitutes egregiousness?
I'm sorry, Your
The
Honor?
killing is what constitutes something being egregious?
Well, egregious, there is no bright line definition for egregiousness. Courts have to look at it on a case-by-case basis, but typically, the courts will find that federal action is egregious when it is so brutal or offensive as to violate traditional notions of fair play or decency.
So,
Go ahead.
go on.
So what constitutes a violation of traditional norms of decency here?
Well, here, Your Honor, because Mr. Pujols does not have the opportunity or the ability to vote in Congress.
So it's the lack of voting, not the death itself, that is egregious,
No, Your Honor.
or a combination of both.
It's the inability to vote coupled with the application of the federal death penalty here that is egregious.
1 + 2 = 3, meaning the death plus the lack of in of itself is egregious.
Yes, Your Honor. In that circumstance, it was held to be egregious.
I'd rather be sexually harassed and killed.
Well, exactly, Your Honor. And that's why sentencing Mr. Pujols to the death penalty here is so egregious, because he did not have consent in enacting the federal death penalty. And it is helpful if we look at things that are not egregious, as there is a sharp distinction between what courts have held to be not egregious and what we have here. For example, in Cruz versus Puerto Rican Power Authority, there an electrical worker was denied a promotion and his boss did not recognize his due pay grade. The courts there held that that was not enough to be egregious or shocking the conscience because it simply did not violate traditional notions of decency. Similarly, in Pagan versus
And
Calderon...
neither is death, by the way, according to you.
I'm sorry, Your Honor?
Neither is death egregious to
Well,
shock the conscience,
Well, Your Honor, death is inherently different than many other things.
but not egregious.
Normally, typically speaking, Your Honor, under the federal death penalty, sentencing a criminal defendant to the death penalty is typically not egregious in the United States. However, because Puerto Rico did not have the adequate representation in Congress
But isn't Puerto Rico part of the United States?
Puerto Rico has a unique relationship with the United States, Your Honor.
As what?
A unique relationship with the United
Oh,
States.
okay.
In
But
that,
death is unique and different, right?
yes, Your Honor.
And is that the connection?
Well,
Puerto Rico is unique and death is different.
Well, it's not just that Puerto Rico is unique, although it is. It's the relationship between Puerto Rico and the United States. Because Puerto Ricans cannot vote in Congress, that's what makes the relationship unique. And applying the death penalty here, given that lack of voting, is also what makes the situation unique.
In your situation with respect to the sexual harassment case,
Yes.
if the sexual harassment case had been a federal law, But Puerto Ricans did not have the right to pass that law, that federal law. Would that have made it even more egregious, or it doesn't matter?
Well, perhaps, Your Honor, it may have made it more egregious. However, that conduct was held to be egregious either way.
But the fact that it was a local law applied to Puerto Rico.
Yes.
It's not a federal law.
No, Your Honor, it's not a federal law in that specific case. But what we're looking at here is the conduct. So we're looking at Puerto Ricans not being able to vote and then sentencing a Puerto Rican to the federal death penalty. That conduct is what is egregious.
But the issue of voting was not present in the sexual harassment case and in the labor case.
Right, Your Honor.
So that had nothing to do with the case, lack of voting.
Exactly. In those cases, the conduct was not held to be egregious. However, if we look at our case in contrast, because Mr. Pujols may be put to death under a statute that he had no representation in enacting, that is egregious. It violates traditional notions of decency that someone can have their life taken from them under a statute that they had no say in creating or enacting.
Excuse me.
Yes,
but
Your
it's
Honor.
only the Constitution in Puerto Rico that has that prohibition.
Well,
So what if they executed him in Atlanta, a federal prison,
Your Honor,
and not in Puerto Rico?
Your Honor, then perhaps.
Would that be respectful
Well, Your Honor,
of the laws and Constitution in Puerto Rico if they didn't execute him over there, but they transported him to Atlanta, Georgia, let's say, and federal penitentiary there, and just execute him there?
well, Puerto Ricans are protected by their constitution no matter where they are.
So you're saying that.
So it's not a physical thing.
So you're saying the Puerto Ricans that live and reside in the United States can't be executed because of the Puerto Rican Constitution?
Your Honor, and I think to answer maybe your questions collectively, sentencing someone in
I didn't hear you. What did you say?
to answer your questions collectively.
Oh.
So,
I would think you can do it collectively. Answer his first and then answer mine.
okay. So, no, Your Honor, it's not that the Constitution, I think if I understand your question correctly, it's not that it's a physical thing. What we're looking at here is taking someone's life when under their own Constitution, that is protected. So taking their life under a federal statute that they had no say in enacting. And I think if we look at the fact that juries have, Your Honor, may I please
Finish.
Thank you.
Because you have to answer my question.
Right. So if we look at the juries in Puerto Rico, the United States government has sought the death penalty on 6 defendants. Yet in the face of overwhelming evidence, Puerto Rican juries have systematically acquitted those defendants. So even if we were to take a defendant to another state and execute them there, even if that were to be constitutional, it violates the deeply held sentiment in Puerto Rico that the death penalty simply should not exist.
I pass on.
Okay. Thank you, Your Honor.
Good afternoon again, Justice. We are at the issue of this case is if the Federal Death Penalty Act is locally inapplicable. During my first presentation, I maintain and defend two main arguments. First, that the Congress has plenary powers over Puerto Rico before and after the approval of the 1952 Constitution. I speak about the Treaty of Paris that the petitioner didn't break this argument. Also, I speak about the insular case of Down versus Bidwell, Barsag versus People has the state maintained the argument that were presented before the United States Constitution. But after I finish my argument, I want to clarify something.
I think you have a minute.
Oh, but let me check the conscience. The
Congress
Congress clearly in Augusta versus Martinez, Sanchez versus Quiñones, Justice Lynch says, and permit a quote, it cannot shock the conscience of court to apply to Puerto Rico is intended by Congress a federal penalty for a federal crime which Congress has applied to the 50 states. The petitioner didn't answer our question, and we're waiting for that.
But it could be argued that Lynch, just because he says it doesn't mean he's right, if he is ignoring what the petitioner would like to argue, that those words are very strong words. So he has simply, I'm telling you, the argument can be made. I'm not saying that it is. That those words still, that not locally applicable, Those words are powerful words, and I think that's really the crux. Why we're all here is the crux of those words in Section 9 of the compact.
But this is the actual, this is the actual.
Excellent answer.
Thank you.
That was rhetorical.
Okay.
Yeah.
Thank you.
No, yeah.
Your Honors. One quick point on rebuttal, if I may, Your Honors.
One quick point.
One quick point. Congress cannot use the judicial system to correct their mistakes. The Puerto Rican Federal Relations Act says that laws that are locally inapplicable shall not apply to Puerto Rico. Your Honors, we are simply asking in this narrow issue of Mr. Pujols and his lack of representation in Congress, sentencing him to the death penalty, this specific narrow issue, Congress implicitly and explicitly did not intend for Puerto Ricans to be sentenced to death under the Federal Death Penalty Act. Thank you.
Thank you.
Thank you.
So,
Is that it? Ready?